Hello everyone, I'm Shivangi Tiwari from Hidayatullah National Law University, and today in this video I'll be dealing with courts and parties. So the topics which I'll be covering in this video are firstly courts, second the separation of power, third the open courts, fourth the public prosecutor, fifth the accused person, and lastly I'll be dealing with legal aids which are available to the citizens. So firstly, I'm going to discuss about the courts, which are the primary institution of justice system in a country. So the main objective of the court is to determine the liability and the duty of the accused person who is brought before the court. So in India, there is a four-tier court structure. At the bottom of the hierarchy is the court of judicial magistrate. It has the statutory competency to try the offences which are punishable for a term less than or equal to 3 years. The Court of Chief Judicial Magistrate comes above it, and it has the competency to try the cases for which the punishment is of a period of less than 7 years. Above both these courts is the Court of District and Sessions Judge. It can try the offences involving the punishment of more than 7 years. The High Courts are the highest judicial authority in any state in the country. High Courts have the appellate jurisdiction, by the virtue of which the High Court can entertain the appeals against the judgment of conviction and acquittal passed by the court subordinate to it, and those judgments can even be reversed by the High Court. The topmost position in the hierarchy of the courts is obtained by the Supreme Court of India. The Supreme Court is also has the power of appellate jurisdiction over the matters related to criminal, civil, constitutional and others over which the decision of High Court has been passed. The Supreme Court is the highest court of appeal, as all the judgments passed by it are binding on the other courts in the country. The framers of the Constitution strive to ensure that the judicial wing of the country remains independent and impartial. And in order to achieve this goal, the various provisions were incorporated in the Constitution of India. Some of them are like section Article 124 to Article 125, Article 127, 146 to 21 of the Constitution of India. Now I'm going to talk about our next topic, which is separation of power. So this doctrine of separation of power was given by it is the modern sense was in the modern sense was formulated by the French writer Montesquieu. So the doctrine aims at the division and separate allocation of powers between the three wings of government, which are legislature, executive and judiciary. In India, the separation of power is the basic structure of constitution. However, in our country, the separation of power is not followed in its strict sense as it is followed in the United States, because in India the separation of function and not that of power is followed. So the reason for non-incorporation of separation of power in the Constitution of India were two. Firstly, the conception of the thought of insertion of provisions relating to separation of powers was at the time when the Constitution of India was already to see the light of the day. Therefore, the framers of the Constitution thought that adding the provision of separation of power at that time was very late, and it would result in the change of the basic structure of the Constitution. Secondly, the framers of the Constitution adopted the British parliamentary system of government, and therefore they felt it better to abstain from adopting the complete separation of power as it is present in the American Constitution. Now we are going to talk about the open courts. So open courts are basically the routine function of the courts. Generally, the public is all allowed to watch the proceedings which take place in the court of law. The advantage of open court is that it brings the transparency in the administration of justice, as the people at large are able to witness the process of administration of justice. And it invokes a responsibility and caution in the minds of those who are under the obligation for the administration of justice to the aggrieved party. The in-camera proceedings is a concept which is an exception to these open court, as the public in these in-camera proceeding is exempted from watching the proceedings of the courts in cases where it is not practical to allow the people other than the parties to accommodate the courtrooms. Even the advocates of the parties are exempted from remaining present in the courts during the in camera proceedings. The matrimonial disputes is an example of such proceedings, as in these cases, it is felt desirable to maintain the secrecy with respect to the identity of the people who are involved in the suit. Next, we are going to talk about the public prosecutor. So, public prosecutors are appointed in almost all the common law country, and they are entrusted with the duty to uphold the principle of natural justice of odi alteram partem. So, according to this doctrine of this principle of natural law, no party should be condemned unheard. Which means that each and every party which is involved in the suit should be heard by the court of law. The prosecutors act as the agent of the Attorney General, and they represent the interest of the general public in the criminal cases. Section 2 of the Code of Criminal Procedure defines the term prosecutor. Section 301 of the Code contains provisions about the appearance of the public prosecutor. According to this section, the public prosecutor can appear and plead without any written submission before any court in which inquiry, trial, or appeal of any case is being heard. So, the question of whether the complainant or any other person can participate in the conduct of the trial, in addition to public prosecutor, and assist the court in case of magistrate trial has been answered under section 302 of the Code of Criminal Procedure, which provides that any person, including the complainant, may, with the permission of magistrate, can take part in the proceeding. However, it is important to note that the police inspectors who has taken part in the investigation of the offence cannot be permitted to take part in the prosecution. So the person permitted by the prosecutor to take part in the prosecution can do so personally or through any pleader. Next, I'm going to talk about the accused person. So an accused person is a party in a criminal proceeding and is the one against whom the criminal proceedings have been initiated. The Code of Criminal Procedure refers to accused person by different names based on the ongoing stage of the trial. So now I'm going to talk about those different names which are given to the accused person according to the code. Firstly, suspect. So the word suspect is used to refer the person whose acts have been apprehended to be against the provisions of the code. Secondly, the term used is accused. So the word accused is used to denote a person against whom the criminal proceedings are initiated. Thirdly, defendant. So defendant, when the court orders the initiation of a main trial, the accused person is referred to as defendant. And finally, the accused person is termed as convict when the court passes a final condemning order or judgment against the accused person, signifying his proven guilty in the case. So there are certain obligations by which the accused person is bound by. So first obligation upon the accused person is the obligation to make an appearance in the court of law when he is called upon by the court. Secondly, an accused person is bound uh, to help in the process of investigation by allowing the investigating agencies personnel to search. Thirdly, an accused person is bound to allow the investigating agencies to make an in-house search or search the personal premises whenever the investigation requires. Fourthly, an accused person is bound to submit the items which are important to carry on the proceedings in the court of law, and he is also bound to allow the doctors appointed by the state on orders of the court to carry on the checkup of his mental state. And lastly, he is bound to allow the medical or biological test of blood or any other biological material which can help in the investigation of the court of the case. So in certain cases, the accused person is found to be of unsound mind, and it is also one of the defenses which is available to the accused party. The same has been dealt with under Section 84 of the Indian Penal Code and Section 328 and Section 338 of the Code of Criminal Procedure under Chapter 35 of the Code. And so it contains the provisions regarding the plea of insanity and the persons with unsound mind, respectively. The commission of any crime in criminal law requires the presence of two main elements, which is mens rea and actus reus. So the general perception is that the person who is of unsound mind lacks mens rea, which is essential for the commission of the crime, and therefore he cannot be held liable for the commission of the crime when it is found that he lacks this basic essential of commission of crime under the criminal law. It is also very important to know that the citizens are guaranteed right to be defended by lawyers. So Article 22 subclause 1 of the Constitution of India makes right to consult and be defended by the legal practitioners of his own choice as a fundamental right. The rationale behind such right is that the general public is usually not aware of the rights and privileges which are guaranteed to them by the law of the land, and therefore it becomes imperative to provide him with such legal aid which would help him to prove his innocence in the court of law. Section 304 subclause 1 and Section 304 subclause 2 of the Code of Criminal Procedure deals with legal aid at state expenses. So Section 304 of 4 subclause 1 of the code contains legal provisions with respect to the right to legal aid to any person who is accused at the state expenses in certain cases. The section provides that where an accused who is appearing before the court of session satisfies the court that because of his indigence or any other reason which he is unable to appoint any legal practitioner of his own choice. And secondly, the section 304 subclause 2 of the code provides that the high courts, with the approval of the state governments, are competent to make rules relating to the mode of selection of pleaders and the fees and allowances to be provided to the pleader who is appointed for the fulfillment of the provision under Section 304 subclause 1 of the code. So that's all for this video. I hope you find this video beneficial. Thank you.